the live stream. I've opened the record in the matter of Kornmeyer versus Kornmeyer, case number 2020-22060S. My name is Marc Crotteau. I'm a referee with the 37th Circuit Court. Because this matter is being heard by a referee, any party has the right to file an objection, asking the judge to review any findings or recommendations that come out of the process. Have to do it within 21 days and in accordance with Michigan court rules. Present for today's hearing by Zoom is Alicia Kornmeyer. Is that correct, ma'am?
Yes, it is.
Also present for today's hearing by Zoom is Dana Porter from the prosecutor's office. Is that correct, ma'am?
Yes.
And I'll note that Jesse Kornmeyer is not present for today's hearing. And I will note that that is most likely the court's fault. The notice that we sent out to the parties for today's hearing gives the wrong Zoom hearing room number. My staff noticed and realized that there'd been a typo in the notices that have been sent out on a couple days. And so we've had that issue with a couple hearings, unfortunately. I will note that this is essentially a rehearing, as it were, of a hearing and to establish this order that happened back in January. Judge declined to sign the order that Ms. Porter prepared under the 7-day rule because, well, for a number of reasons, but in particular because there is an NA case involving the parents in which the children were removed. They were with Mr. Kornmeyer, then they were not with Mr. Kornmeyer anymore. Mr. Kornmeyer was incarcerated for a time. He's no longer incarcerated. And that how should we say, it complicates the child support order. And she directed that I set the matter for another hearing in order to address those issues. And Ms. Porter, I made a point of making sure that your office had notice, just because Judge hasn't in fact signed the order in any way, much less or so. I guess let me ask you, Ms. Porter, is there any record that you want to make from your standpoint?
I do. I am objecting to the adjournment. On January 19th, when we had the hearing, testimony was taken from Alicia Kornmeyer and from Jesse Kornmeyer, who, yes, was in jail at that time. He'd stated what date he was going to be released. He stated his income capacity. Testimony was taken from both parties. Alicia Kornmeyer stated her income capacity. We specifically talked about the NA case, and this court directed me to put the language in the proposed order that is in there, not pursuant to NA. We prepared everything consistent with what was placed on the record, and I feel like there's nothing else that we can do different to move this case along. We filed this October 29th, had the hearing in January. The order still hasn't been denied. Nothing's going to change. So I'm asking the court to sign the order and route it to judge. I mean, I didn't even understand why we were here today because nothing has changed since our January hearing.
Actually, I think you do raise an interesting point, and I think I got hung up on the fact that Mr. Kornmeyer didn't get notice for today. So I'm not sure that, so let me back that up. As I understand the judge's concern, her concern is that the order has Mr. Kornmeyer paying Ms. Kornmeyer child support from October through January, approximately January 15th, because the children were in fact with Mr. Kornmeyer and not with Ms. Kornmeyer in that time frame, that there's I guess an overnight issue.
We gave them split custody. That's what they testified to, 182.5.
Double check. So I think I might be able to address that.
I mean, obviously, I'm not angry with the court. I'm just very frustrated that the court is continuing to tell me that I'm not getting cases in within my guidelines. But we did.
So,
And at the time of hearing, this is what the testimony and the proofs were. In January, it is now April. We're talking over 3 months later. This order hasn't been denied, hasn't been granted.
all right. Ms. Cornmeyer, before I start making decisions, is there anything you'd like to add? Anything you want to tell me about?
Well, I mean, as far as child support goes, I had been taking care of Anastasia solely on my own without any financial support from him starting August 2019. My son was born in November of 2019. So then from November to, November 2020, as far as like rearages go, I do believe that I would be owed all that back child support if it goes back that far. And I'm kind of confused on if there will be payments for those times. Again, that was August 2019 for Anastasia, and then November 2019 for both of them moving forward to November 2020 when I was arrested, and that's when they were removed from my care. What's kind of bumming me out about this whole thing is that now that, we're finally getting somewhere with this child support case where I had, financial support would have been beneficial prior to November 2020. It's just now making some headway here. But now the support order is being redirected towards my mom with the foster care situation going on right now. Ideally, I would love to, get that NA case off record. I'm hoping that it gets dropped, of course, and the kids come back to me, but it's just a bummer that just as soon as I finally get somewhere with it, it's, going to be taken away anyways.
So let me jump in and say, I think that I can address judges' concerns by resending the order, the underlying order to judge for signature, but having my staff, and I'll have my staff prepare this, Ms. Porter, doing a 2-tiered order, child support order, covering the period from the date of filing in October the 29th, I think, of this year, through the time in January when the children were with Mr. Kornmeier. Then addressing the fact that Mr. Kornmeier became incarcerated and the children were removed and placed in the department for care and supervision, and going forward that way. I think that will address judges' concerns. Go ahead, Ms. Kornmeier.
I'm referring to dates even prior to that. I'm saying Jesse stopped financially supporting our daughter Anastasia in August of 2019.
So
and for an entire year.
Let me jump in there, ma'am. And let me jump in and say, for better or worse, a court order cannot have effect any earlier than essentially the date when the lawsuit is filed. When the underlying suit exists. And that was, I think, October 29th of 2020.
Right.
So whatever the rights and wrongs of things prior to that, this court order can't have anything to do with those because the court case didn't exist that kind of
I have a
Okay.
follow-up question.
thing. Go ahead.
Okay.
So in my proposed order regarding the custody, like I had stated on the record, we had placed that the parties were having joint legal and joint physical because the court said not pursuant to the NA. So if the court is going to be changing those orders, I feel like, is that going to be acceptable to Judge Yost Johnson, or does she
I don't
want it
know the
pursuant?
answer. I wish I did. I'm
Does the
going
court-
to, the only thing that I'm going to change and send to judge is the child support portion. I'm going to leave everything else the same.
Okay.
Because, and I will say this, my understanding of her concern with the proposed order is that the child support part was incorrect.
Okay.
And so I'm going to have my staff prepare that, I guess, by way of an addendum or maybe just replacing the child support portion. I'm not sure. I'll have to consult with my staff about the best way to actually get that part done.
Certainly.
But we'll get that done. I will resubmit everything to judge and we'll see what judge has to say about it.
Okay.
And go forward from there. So, Ms. Porter, anything else that we need to address from your standpoint?
No, thank you.
Ms. Kornmeyer, anything else from your standpoint?
No.
All right, folks, I'll remind everyone that they have, and actually I probably should say, I'm doing that even though Mr. Kornmeyer isn't present today, and that as far as I can tell, his lack of presence today is on the court. I'm going to go forward because I don't think anything that he might say would change the decision that needs to be made based on what Judge is telling me. So I will now